I want to be very clear. You have misused resources appropriated by Congress. You've engaged in unethical behavior. You have repeatedly made false and misleading statements to Congress and to the press, and you've undermined the separation of powers and disregarded the role of Congress and the courts. Bottom line, you lie with impunity, you reject checks and balances, and you ignore Congress and the courts. Your options are limited. Either you're going to resign, Trump's going to fire you, or you will be impeached. I've already called for your resignation. You may remember I hand-delivered my request to you back in May, and I urge you to reconsider resignation because I've taken the first step towards your impeachment, and I've called on the Judiciary Committee.
The most dangerous evidence in American political history is not a rumor. It's not anonymous sourcing. It's not a partisan leak. It's a recorded voice, and it's his. Before we even get to policy or politics, sit with that. A former president, later returned to office, captured on audio discussing a classified military plan with people who had no legal right to see it, not speculating, not misremembering, acknowledging, in his own words, that the document remained classified, acknowledging he could not declassify it after leaving office. That single admission fractures the public defense he sold for years. And when a defense collapses, the legal exposure widens. This is not about optics. It's about evidence calibrated for conviction. The special counsel who assembled the case did not traffic in innuendo. He documented recordings, video surveillance, email chains, phone logs, sworn testimony from insiders who were in the room when pressure was applied, when directives were issued, when lines were crossed. This was not a circumstantial mosaic. It was direct proof. And direct proof does something psychologically destabilizing to a legal team, because you cannot cross-examine a recording into silence.
To open an investigation into your lawlessness. Mr. Chairman, I know that at the end we'll be entering a number of articles into consent, but since I have a few moments, I ask unanimous consent to enter into the record a letter calling the Judiciary Committee to investigate Secretary Noem's impeachable offenses. Whatever you choose, the American people will have justice, Secretary, and you will be held accountable. I'm going to make sure of that every single day. With that, Mr. Chair, I yield back.
You cannot spin surveillance footage into ambiguity. You cannot wish away your client's own voice. Now here is where the stakes shift. Despite indictments, despite grand jury findings of probable cause, despite what the prosecutor described under oath as proof beyond a reasonable doubt, there was no trial, not because the evidence failed, because the defendant reclaimed the presidency. Department of Justice policy, long-standing, controversial, structurally protective, bars the prosecution of a sitting president. So, the case is halted, not dismissed for weakness, not withdrawn for lack of proof, paused by institutional design. And that distinction is everything. Because when prosecution stops for policy reasons, not evidentiary ones, the underlying conduct remains unresolved. The constitutional question lingers. The record does not evaporate, it waits. Let's widen the aperture. Start with the election interference investigation. According to sworn filings and testimony, the evidence showed a coordinated effort to overturn certified results after repeated internal acknowledgments that fraud claims were baseless. Advisors said it. The Attorney General said it. Campaign officials said it. The fraud narrative collapsed internally. Publicly, it accelerated. That divergence is not political hardball. If proven, it is intent. And intent is the spine of criminal law. Witnesses described pressure campaigns targeting state officials, plans involving alternate slates of electors, draft memos outlining pathways to reject certified votes, communications tracing awareness at the highest levels. This was not spontaneous chaos. It was structured. When a president allegedly uses the machinery of office to subvert certified results, that's not just an election dispute. That's a stress test of constitutional order. Now consider the classified documents case. Hundreds of sensitive materials removed from secure facilities and stored at a private club, some bearing markings at the highest levels of national security, requests for return, subpoenas issued, surveillance footage capturing boxes moved after those requests, employees describing directions to relocate materials, physical documents recovered, and layered over it all, the Bedminster recording. On that tape, the former president reportedly references a military plan and concedes its classified status. That single acknowledgement undercuts the sweeping public claim of automatic declassification by thought alone. It narrows defenses. It sharpens exposure. This is where the legal analysis becomes unavoidable. The Constitution vests executive power in the president. It does not grant lifelong immunity from federal criminal law. The separation of powers guards against tyranny by dividing authority. But when one branch insulates itself from accountability indefinitely, that balance destabilizes. Temporary immunity under DOJ policy is not constitutional text. It is internal guidance. It creates delay, not absolution. And delay can be strategic, because evidence preserved is evidence pending. The special counsel did something rare. He documented publicly that the case met the standard of proof beyond a reasonable doubt. That phrase is not rhetorical flourish. It is the highest burden in American law. To assert it publicly is to stake a professional legacy. So ask yourself, why make that declaration if the file were thin? Here's the destabilizing implication. The prosecution did not dissolve. It was boxed, cataloged, indexed, authenticated, witnesses identified, legal theories tested before grand juries, indictments secured, a trial-ready framework assembled, a prosecution in suspension, and suspension is not exoneration. This is the misconception weaponized in political discourse, that absence of conviction equals innocence. It does not, especially when absence is engineered by institutional constraint rather than evidentiary collapse. A grand jury reviewed the materials and returned charges. That is a constitutional safeguard, not a partisan body. Ordinary citizens presented with evidence found probable cause to believe crimes were committed. That finding does not disappear because a calendar turned. Now we arrive at the constitutional fault line. If a president can run out the clock on prosecution by securing office, what incentive structure does that create? If political victory immunizes alleged criminal exposure, does the electoral process become a shield against legal accountability? That is not a theoretical question. It is a systemic vulnerability. History offers precedent. Nixon faced tapes. The evidence was so direct, so irrefutable, that political support collapsed before trial. Accountability came through resignation under threat of removal. Clinton faced impeachment. The evidence produced political consequences, but not removal. Different facts, different thresholds. Here, the prosecutor asserts the strongest evidentiary package ever assembled against a president. Recordings, physical documents, surveillance, insider testimony, and yet no adjudication. That tension between evidentiary weight and institutional pause is the pressure point. Because the evidence does not degrade with time. Recordings remain recordings. Documents remain documents. Sworn statements remain under penalty of perjury. Federal records laws preserve them. Career officials archive them. When the barrier lifts, if it lifts, the machinery restarts not from zero, but from near completion, which raises the next escalation. What happens to democratic norms when half the country is told the case was a hoax, while the prosecuting authority insists it was trial-ready? Information warfare thrives in that gap. Misinformation fills the vacuum left by delayed justice, and delay favors narrative manipulation. The longer accountability is deferred, the more entrenched the myth of exoneration becomes. The more normalized the idea that power shields itself. The more fatigue sets in among citizens who assume nothing will ever happen. Institutional decay is rarely explosive. It is incremental. It is the quiet erosion of expectations that law applies equally. So this is not merely about one individual. It is about precedent. If the presidency becomes a revolving sanctuary from prosecution, the separation of powers distorts. If evidence of obstruction, retention of classified material, or conspiracy to overturn certified results can be frozen indefinitely by electoral timing, future actors take note. That is how norms collapse, not in spectacle, but in repetition. And yet, the record exists. The special counsel placed it into the bloodstream of public record, congressional testimony, detailed reports, indictments. He ensured the evidence would outlive the moment. Which brings us to the uncomfortable realization. The decisive variable is no longer the strength of the evidence. It is the will of institutions and the vigilance of citizens. Because institutions respond to pressure, they calibrate to public demand for accountability. They measure political risk. If civic attention drifts, if narratives of innocence solidify unchallenged, if misinformation overwhelms documented fact, the path to revival narrows. But if the record is remembered, accurately, relentlessly, then the box on the shelf remains a live instrument of potential justice. You are not a passive observer in that equation. The theme tonight is not just the existence of evidence, it is the fragility of accountability when power collides with delay. If you disengage, if you allow the myth of exoneration to harden into conventional wisdom, the constitutional stress becomes permanent. Stay connected to this story not out of spectacle, but out of responsibility. Track the legal developments. Challenge false equivalencies when you hear them. Share verified facts when disinformation surfaces. Refuse to let paused be rewritten as proven innocent. Because the health of a democracy depends less on the evidence assembled than on whether its citizens demand that evidence see daylight. If you want institutions to resist decay, your attention cannot decay first.